we are discussing on mandatory dematerialization of shares for private companies. Rule 9B. The Ministry of Corporate Affairs has made dematerialization of securities mandatory for private companies, excluding small companies. The deadline is 30th compliance process. So this is the must watch for company secretaries, directors, and compliance professionals, investors, and startups. So we'll see the background of the dematerialization in India. Dematerialization actually began with the Depositories Act 1996. So the foundation for electronic holding and transfer of securities is Depositories Act 1996. That is the foundation. There are two depositories available, that is NSDL and CDSL. So in 2004, SEBI flagged issues with paper-based shares like frauds, signature mismatches, transfer of delays, and high costs. So over time, demat became mandatory for listed companies, large public issues. So via Companies Act 1956 and Companies Act 2013. So unlisted public companies via Rule 9A 2018. But until recently, private companies were excluded. With the introduction Rule 9B, the legal mandate on October 27, 2023, MCA notified the company's prospectus and allotment of securities, Second Amendment Rules 2023. So introduced then Rule 9B into allotment rules. The applicability, every private company, as per Rule 9B, every private company except those classified as small company as on 31 March 2023. So there is a mandate, is a mandatory requirement. So deadline again extended to September 30th, 2024. Again further extended to June 30th, 2025. So this is the deadline, June 30th, 2025. So after these dates, all existing shares must be in demat form. No issue or transfer of physical shares allowed. So what are the objectives and rationale behind this? The objectives are combat benami transactions, to arrest benami transactions, enhance corporate transparency, prevent fraudulent pledges or fake share certificates, ease share pledging, and foreclosure by banks, financial institutions, ensure stamp duty collection on share transfers, that will become very easy, and improve beneficial ownership tracking, that would be very convenient, and reduce shell companies and abusing mechanism and money laundering, encourage digital governance and modernization of India's corporate structure. These are all the objectives behind this dematerialization. And what are the benefits of demat for private companies? Transparency and traceability, digital audit trail for all transactions, cost efficiency because of no printing and storing physical certificates. So this is a cost efficiency. And simplified transfers, faster share transfers and lesser disputes because of the demat share transfers, and improved compliances, real-time monitoring by regulators, very convenient, and investor confidence. Investors build credibility and investor get confidence. It builds no credibility with banks and investors. Better governance strengthens shareholder identification is a very easy. And stamp duty exemption on demat share transfers is for future fundraising and rights issues, buybacks, and become the process will become very smoother. What are the compliance requirements for this dematerialization? First, the company has to obtain ISIN. ISIN full form International Securities Identification Number. This is called ISIN, International Securities Identification Number. Enter into tripartite agreement with RTA and depository. Depositories NSDL or CDSL or both. Appoint registrar and share transfer agent RTA. File required documents including board resolution and financials. So for shareholders, what they have to do, they have to open a demat account, submit a demat request to RTA, convert physical shares into demat via DP. What about the penalties for non-compliance? Companies cannot issue or cannot transfer securities if not dematerialized. Penalty under Section 450 of Companies Act 2013. We know 10,000 is a penalty plus 1,000 per day for continuing default. Key personals like promoters, directors must hold demat shares to issue even further bonus, do rights issues, etc. Physical shares can't be sold post deadline unless converted into demat. Deadline is 30th June 2025. So, what are the practical challenges which we are facing during the process of this dematerialization? So, if we discuss the practical difficulties, ISIN issued, ISIN creation, ISIN issuance, delays from depositories. It is getting delayed. High compliance burden on small private companies. Lack of awareness among the promoters and the shareholders. Difficulty for foreign investors. PAN requirement and physical KYC documentation. No reliance on the digital signatures. This is the difficulty for foreign investors. Funding limitations. The non-demat shares restrict capital raising. And if you see the international comparison, like the comparison with United Kingdom, Singapore, China. So we'll discuss the comparison with few countries like UK. Focus on public companies only. In United Kingdom, they focus on the public companies only. Then CREST system from 1996. No demat mandate for private companies. And you see in Singapore, SGX handles listed securities, cross-border efficacy. There is no requirement for private company demat mandatory. So even in China market segmented approach, that is market segmented approach, no equivalent demat mandate for private firms. So India's Rule 9B, it is a unique and assertive move to regulate private company shareholding through digitization. Strategic takeaways for companies. Act early to avoid last minute compliance burden. We are already at fag. Educate shareholders about the demat benefits and process. Collaborate with the professional companies and RTS. Ensure foreign investors complete KYC on time. Use this opportunity to streamline cap table management. So now the conclusion is Rule 9B. Rule 9B is not just a regulatory requirement. It is a bold step towards transparency, towards efficiency, and investor protection in India's private corporate landscape. Yes, the compliance process has its challenges, but the long-term benefits far overweigh the short-term hurdles. The greater advantage, if you see the long-term, private companies must see this as an investment in the governance. Start early, stay compliant, and you will not only meet the June 30th, 2025 deadline, but also stand stronger in India's growing business ecosystem. Thank you for watching. If you found this video helpful, don't forget to like, share, and subscribe for more deep dives into corporate law and compliance. We have two channels, RR Corporates and RR Legal Talks. Please do subscribe both channels for more updates on corporate laws, updates on public issues, updates on NCLT matters. Please hit bell icon so that you will not miss any of the latest updates. Thank you.